Here we go. We're reading from Faces at the Bottom of the Well by Derek Bell, one of the great books, great reference book. And we're reading about a scheme he has in there, or a plan for resegregation. The president committed himself and his administration the effective enforcement of the Racial Preference Licensing Act. It is time, he declared, to bring hard-headed realism rather than well-intentioned idealism to bear on our long-standing racial problems. Policies adopted because they seemed right having usually failed. Actions taken to promote justice for blacks have brought injustice to whites without appreciably improving the status or standards of living for blacks, particularly for those who most need the protection those actions were intended to provide. Within the memories of many of our citizens, this nation has both affirmed police policies and racial segregation and advocated policies of racial integration. Neither approach has been either satisfactory or effective in furthering harmony and domestic tranquility. Recalling the Civil Rights Act of 1964 and its 1991 amendments, the president pointed out that while the once controversial public accommodations provisions in the original 1964 Act received unanimous judicial approval in the year of its adoption, even 3 decades later, the Act's protection function, particularly in the employment area, had been undermined by both unenthusiastic enforcement and judicial decisions construing its provisions ever more narrowly. As we all know, the president continued, the Supreme Court has now raised grave questions about the continued validity of the 1964 Act and the Fair Housing Act of 1968, along with their various predecessors and supplemental amendments as applied to racial discrimination. The court stopped just short of declaring unconstitutional all laws prohibiting racial discrimination and found that the existing Civil Rights Act were inconsistent with what is viewed as the essential racial forgiveness principle in the landmark decision of Brown v. Board of Education of 1954. The court announced further that nothing in its decision was intended to affect the validity of the statute's protection against discrimination based on sex, national origin, and religion. This is, of course, not an occasion for a legal seminar, but it is important that all citizens understand the background of the new racial preference statute we signed this evening. The Supreme Court expressed its concern that existing civil rights statutes create racial categories that fail to meet the heavy burden of justification placed on any governmental policy that seeks to classify persons on the basis of race. In 1989, the court held that this heavy burden, called the strict scrutiny standard, applied to remedial as well as to invidious racial classification. Our highest court reasoned that its 1954 decision in the landmark case of Brown v. Board of Education did not seek to identify and punish wrongdoers, and the implementation order in Brown 2, a year later, did not require immediate enforcement. Rather, Brown 2 asserted that delay was required, not only to permit time for the major changes required in Southern school policies, but also, and this is important, to enable accommodation to school integration, which ran counter to the views and strong emotions of most Southern whites. In line with this reasoning, the president continued, the court referred with approval to the views of the late Yale law professor Alexander Bickel, who contended that any effort to enforce Brown as a criminal law would have failed, as have alcohol prohibition, anti-gambling, most sex laws, and other laws policing morals. Bickel said, it follows that in achieving integration, the task of the law was not to punish lawbreakers, but to diminish their number. Now, the court has found Professor Bickel's argument compelling, viewed from the perspective provided by 4 decades. The court says now that Brown was basically a call for a higher morality, rather than a judicial decree authorizing Congress to coerce behavior allegedly unjust to blacks because that behavior recognized generally acknowledged differences in racial groups. This characteristic or characterization of Brown explains why Brown was more effective as an enforcement tool than were other morals policing laws such as alcohol prohibition, anti gambling, and sex laws, all of which are hard to enforce precisely because they seek to protect our citizens' health and welfare against what a legislature deems self abuse. So, again, they're delving into the civil rights laws and why they're not effective. Um, and they're not effective. They haven't been. They haven't helped because you can't change people's minds and hearts. And even if you could change their minds and hearts to a point where they're um, tolerant of other people when they're in their space, that's still not going to make them give up what they have to share with another group of people they don't consider their own, if that makes any sense. For instance, there was no public school system in the South before Reconstruction, as far as I understand. So, black lawmakers during Reconstruction created a public system, school system in the South for everybody. Whites had no public school system in the South before blacks pushed for it. And the whites turned around and said, well, we don't want blacks in our schools. You can't deal with these people. You can't expect much from these people. So I don't know what we're going to do, but people are still trying to convince hateful people, mindless people, thoughtless people to be loving and thoughtful and mindful. And it's a free country. You can't force them to do it. Until next time, thank you for your support. And take care of your mind, take care of your body, and please, please, please be safe.